It's August 8th, 2009, Ron and Robert, and we are dealing with
A Layman's Guide to California Family Law, copyright 2009. So, Robert, what do you tell clients who ask you the question, what exactly is no-fault divorce?
Well, Ron, no fault is exactly that, no fault. There are some very few exceptions in the state of California, most of which are not often granted unless you have very, very, very specific evidence. We won't get into those at the moment, but yes, there are a few.
I actually had cases in the early 70s. I started my practice in 1970 with the inception of the new California Family Law Act, which introduced no-fault divorce and ended fault divorce. And people are astonished today to learn that prior to 1970, you had to have grounds for a divorce. And I had people that came in to see me who'd applied for a divorce years earlier and had been denied. Mm-hmm. They couldn't get a divorce because they didn't have grounds for a divorce. And they had grounds such as mental cruelty, physical abuse, infidelity, drunkenness. So they had to prove that the marriage somehow had been tainted and poisoned, and so the marriage had to be ended. And of course, the courts had the jurisdiction and the discretion to divide estates unequally. And so they could find that he was a domestic violence perpetrator and give 30% of the estate to him and 70% of the estate to the wife. So they could jiggle the accounts and the books and decide who gets what and who gets how much and who gets to be a parent and so forth. And it was astonishing to people to learn that at the end of the 60s, with the inception of the 70s, now it's all 50-50. There's just irreconcilable differences or incurable insanity, and no one can prove incurable insanity without a huge trial and lots of costly experts. So everybody opted for irreconcilable differences, and the court finds irreconcilable differences if one party says they have them and the other party says they don't. That in itself is irreconcilable differences.
I actually had that trial. I had a trial in front of an Abraham Gorenfeld, a judge here in Los Angeles, actually a commissioner here in Los Angeles for many years, wonderful man. And we were standing in front of the judge, and the opposing counsel and his client said, there's nothing that this man can say that I can't agree to. We don't have irreconcilable differences. And Judge Gorenfeld just looked down and said, ma'am, he wants a divorce. Can you agree to that? She said, no. He said, well, then you've got irreconcilable differences.
Exactly the point. So the next question I get from people who want to know their options and their alternatives is, what choices do I have in choosing a divorce?
In choosing a divorce, well, there are different types of divorce. So there's a real question there. It's what do you want? Do you want downright burn 'em up litigation? And there's basic litigation. There's mediation. There's arbitration. There's various types. We can unbundle today, which we've never been able to do before.
Unbundle. Tell me what that is.
Unbundling. Taking pieces of your case, and you can be responsible, the client can be responsible for portions of their case, or we can be responsible for that, the attorneys can. And by doing that, there are many, many portions of a case that are rota routine that can save the client thousands and thousands of dollars.
What are some of the things that a client might want to do?
Draft some of their first documentation, declarations, for instance, and our office provides them with guidelines as to what to do and how to do that, and it's easier to do that way. And then we just pick up and do the polishing and put it in the proper form and then send that to court. That's a lot cheaper.
That sounds like, isn't that kind of what business lawyers have done traditionally from day one? They let you choose whether you want to do the drafting or whether you want the lawyer to do the negotiating, or whether they're going to handle discovery or filing papers or appearing in court. That's kind of like what business lawyers do. They let the client choose the service that the client wants and needs and can afford.
Correct. And I think that's been the general area outside of transactional law, inside transactional law for years. And then all of a sudden we've changes and for reasons exactly of what we saw in the 70s and 80s. where the economy was changing. And I think we're seeing that again now. One of the most important issues would be the values of what people can afford today. I mean, when you have down markets as we have today, and you and I both went through this with our clients back in the early 90s. We had the recession in the 90s. Wasn't quite as deep as the current one, but we were dealing with all the same issues that we deal with today.
Well, I like to tell people that there are 6 basic options. I explain that the kitchen table is the fastest, cheapest, and most affordable.
And what would that be?
Some couples can sit down with a pad of paper and a pen and say, here's what we're going to do about the kids. Here's how we're going to pay the bills. Here's what we'll do with the property. And we'll split the cost of whatever it costs to hire someone to put this all together. And of course, now they have licensed document assistants. California has a new professional, LDA, and all they do is fill out paperwork. They're not paralegals. They're not lawyers. They don't give advice, but you tell them what you want. They fill out the forms for you. And of course, if they can do it all themselves, that's the fastest, cheapest, most efficient. Mediation is number 2. That's the one that everybody seems to understand and know about. It's merely facilitated negotiation. You go to a third party who serves as a neutral facilitator, is not an advocate, cannot give legal advice, must admonish you to seek independent advice when the whole process is done, but they can present options and alternatives and different scenarios and invite the parties to choose how they want this done and then draw up the deal memorandum of understanding they can take to their attorneys, or sometimes even do all of the work. If you have a lawyer mediator, typically they'll draft the papers and file them to Superior Court. And the new policy in Los Angeles is they actually favor consensual dispute resolution. And if you come in with a mediation or a collaboration, you go to the top of the list with regard to processing and entering judgments, whereas the other cases are going to wait 6 to 12 weeks till the clerks get around to it because they're so backed up and understaffed.
And that's a question that I get all the time from clients now, is especially prospective clients. They want to know, well, should I have my ultimate mediated documents or mediated agreement reviewed by an attorney? What would you tell them?
I tell them that only an attorney can tell you whether or not you need an attorney. The problem with being human is you don't know what you don't know. And even when people come into my office and they just want to use a paralegal, my practice is always, yeah, fine, great. Let's just spend a couple of minutes reviewing the main points of the agreement to see if you've covered everything, if you've left out anything, if you've overlooked something or been remiss in some way. So I think it takes an attorney to tell you, great job, you don't need an attorney.